Alaska law sets forth clear requirements for write-in ballots to be counted. The candidate's name must be written on the ballot, and law goes on to specify that the name must be written as it appears on the candidate's write-in declaration of candidacy. This statute sets forth a clear-cut, bright-line rule. The question before the state in determining the validity of a write-in ballot is simply, does it contain the candidate's name? It's a simple yes or no question. The statute is not 1515-360, A10, and 11, is not a delegation of authority to the state to decide whether some words are or are not the candidate's name. It's not a delegation of discretion or power to decide for them to allow state officials to decide for themselves whether or not particular write-in ballots are valid. It establishes a bright line rule. If the candidate's name is on the ballot, it counts as valid. If it is not, the ballot is invalid. The Lieutenant Governor and the Director of the Division of Elections argue that they, in effect, have the power to amend this statute by deciding to accept as valid and count ballots that indisputably do not contain the candidate's name, that contain anything ranging from minor misspellings to words that by most reasonable standards would not even be considered a variation on the candidate's name or would be unrecognizable as a variation on the candidate's name, because, in their opinion, the voter intended to cast a ballot for a particular candidate. So under the clear-cut standards that the state legislature enacted through A10 and 11, the legislature did not say you may count a ballot as valid if it is clear to you that the voter intended to cast it for a particular candidate. The statute is simply not that type of grant of discretion or power. It establishes a clear-cut rule and asks, is that name on the ballot? My name, for example, is Morley. I represent Joe Miller. Marley, a variation on my name, haunts Ebenezer Scrooge, two different names. Writing one on the ballot, it would not be satisfying the criteria set forth in the statute to be counted. The position that the state is articulating is inviting this court in the name of voter intent to ignore the plain standards set forth in the statute and to imply a substitute standard under the ballot. The problem with that position is that this court, as recently as the Edgemont case, has held that where a requirement in election law is mandatory, it will be strictly construed. It will be strictly enforced.
But if the right to vote, which our cases have certainly indicated, is a key right in a participatory democracy, and if the right to freely cast one's ballot is a fundamental right, how do we preserve the rights of the voters and not to be disenfranchised if we interpret the statute the way you suggest? And in fact, isn't it our duty to interpret the statute in a way that doesn't disenfranchise any voter?
Your Honor, respectfully, no, because again, as this court held, when you're dealing with mandatory statutory provisions as opposed to directory ones, with mandatory statutory provisions such as A10 and A11, this court must adopt a strict construction under this court's own precedents. And again, I refer you to Edgemont, I refer you to the Jeffrey case, in which this court effectively nullified the votes of a majority of voters in an election based on a failure to comply with the strict requirements of a statute strictly applied.
You know, just simply pointing to 1515, 360B as being mandatory, doesn't that still beg the question of what it means to have the name?
Not exactly, Your Honor, because as this court has held, and you'll have to pardon my pronunciation, in City of Kotzebue versus State, this court construes statutes as a whole. So it's not going to look just at B in isolation. It's not going to look at A10 and A11 in isolation. It's going to look at the language of B, the repeated exhortations in B. This is mandatory. There are no exceptions. Ballots will not be counted if they fail to satisfy these rules, and construe A10 and A11 in light of B's emphatic, repeated, otherwise meaningless language that ballots that don't meet these criteria, that don't have the candidate's name on it, simply are not to be counted. And again, Your Honor, B also tells us that A is mandatory, which under this court's general canons of construction separately counsels for a strict construction of A10 and 11. And even if this court looks to the voter intent cases that Your Honor referred to earlier, Even those voter intent cases, even Edgemont, even Carr itself distinguishes between merely directory provisions of the election code and mandatory provisions such as those we're dealing with here, and tells us to give those mandatory provisions a strict construction.